this is the only funny part that I always feel, because we're talking to each other and suddenly I move into this formal mode of Jawad. Thank you very much for being part of the symposium. It just feels a little, for me, a little this thing, but I have, this is a different session. It's recorded separately. So Jawad, thank you very much. Always a pleasure having you, and your interesting thoughts are always.
In fact, I must be thanking you, Vikram, for the opportunity.
Okay, we've already got a comment on that WhatsApp group.
Uh-huh.
Very interesting. Mediator as a philosopher. Someone's put that out. So I think people are watching, and at least something interesting is going to come out in terms of thought process. So, Jawad, what I'll do is just I just told you, let me for a second just put out just the basics, that where people can find some information. Not that it's something important. Mediatorvikram.com actually would have it, because the problem is reaching out as to where people can find information, because social media posts, I've realized, only limited people are shown those. That's the algorithm of social media, so that we can't do too much about that. So mediatorvikram.com, basic idea will be there, shows will be there, shows and events will give you a certain idea there. There's a newsletter on LinkedIn that I put out. I'll put the link here also, so people go there. World Mediation Circle, definitely we have to, I'm creating in every country, every organization, every school, community. That's the larger goal. But India Mediation Circle has to be put out fast in a sense, obviously take its time, but let's put that into place. Support, definitely you should. And of course, there are other various events and everything. So lots of information there. We won't take Jawad's time on that. And on the description of this video, you'll find a link to Patreon. If someone wants to go there and become a patron, I'm very happy. So Jawad, it's all yours. If you want to tell us about yourself, please, because we've been on the other shows, but let's just take a little introduction and then move. And it's your show. I'm out of this. I'm just listening.
Thanks, Vikram. Very briefly, let me just talk about my journey in this mediation. Just give me 1 minute. Just give me 1 minute.
Yeah.
Yeah, sorry, Vikram. There was some outside noise that was coming in. So.
No.
Yeah, so Vikram, well, about myself, I was, I entered the legal profession sometime in 1988. And mediation was a sort of a, serendipitous discovery for me. It was sometime in 2006 when I was 2 years short of completing 2 decades as a lawyer. I was settled in my black robes. It endowed me with a certain kind of pomposity, perhaps stemming from my belief that I was in a noble profession, rendering a great service to humanity. But, there was always this sense of dissatisfaction. There was uncertainty, there were delays, costs, and so on. It was then that I, saw this board, Tamil Nadu Mediation and Conciliation Center, in the Madras High Court, where I was practicing. And I was quite curious about it. I walked in to inquire what it was all about. And then I came to know that there was a mediation training program that was coming up soon. And the center was looking for delegates from the lawyers who would be willing to get trained as mediators and offer their services to the center. Of course, I knew Mr. Sriram Panchu for a long time, but I met him there in the TNMCC. And he encouraged me to enroll for the training, along with Anu also enrolled, my wife Anu also enrolled. So as fate would have it, this became a turning point in my life. So I found the, idea to be very interesting and novel, that you don't tell, for once you don't tell parties in conflict who's right and who's wrong, but you guide them to a place from where they realized that what they really need to do is to resolve the conflict themselves. So I realized that what was fundamentally different in this process was the potential for parties to take the responsibility for the final resolution themselves and attain a more holistic satisfaction from the outcome. Because ultimately it was their decision, right? So that is what I felt. Now, the realization that, what was this dissatisfaction that I was feeling actually could find expression, because I could not actually place my finger on it. Why am I dissatisfied with this process of litigation? Because I didn't know that there were alternatives. Okay. So when I realized this alternative, then I realized, okay, here's where, things were going wrong. Because I had fought cases, won some, lost some. There was, of course, disappointment with the lost ones, but what was ironical was that it was essentially a zero-sum game, and there was no satisfaction in the victories also. And so was the case with the clients. They also felt the same way. For some time, I went about doing both litigation and mediation. But then I realized that the mindset and the approach needed for these two were diametrically opposed. So in litigation, you needed the killer instinct to fight and kill. In mediation, you needed a more inclusive approach where your opponent, whether it is the opposite party or the advocate, you don't perceive them as adversaries whom you have to defeat at any cost. But, perhaps people with a different perception of the problem and with whom you need to sit, talk, understand, work together, find solutions that work for both sides. Now, I became so wedded to the concept of mediation that I decided to, quit litigation completely. At that time, it was a difficult decision to make because mediation was still a very nascent concept, and people looked at us as sort of tree huggers, very idealistic people who have no touch with reality. And even judges and lawyers had a very simplistic understanding of it, a process where you talk to, they thought that it was a very ad hoc process where you just talk to both sides, advise them that, okay, you're right, you're wrong, and this is what you need to do, give them the solution. There was a lot of criticism against mediation. But what happened was I also got the opportunity to become a trainer in mediation. I know you don't believe that mediation requires any training at all. But for me, both mediation and mediation training was a life-changing experience. It gave me an opportunity to travel to different parts of the country, meet some very interesting people, also different parts of the world. And this entire journey of about 15 years has been an incredible learning experience and also a very humbling. Earlier, when Mr. Panchu was talking about whether a mediator should be a philosopher or whether a philosopher can be a mediator, that's a very insightful thing to say, because what in the course of this I realized was that there is a philosophy behind mediation, and which I'll come to that. All along, there's a very, very sexist quote that is attributed to Socrates, where he said to have said that by all means marry. If you get a good wife, you'll be happy, and if you don't get a good wife, you'll become a philosopher. Okay, so fortunately, my life partner is a very good person. So there was no opportunity for me to become really philosophical. So, but come to think of it, the more I think about it, the more I feel that you need to have a philosophical bent of mind to perhaps to be an effective mediator. I had this opportunity, or in fact, I have this opportunity of working with young students, because I had the chance to conduct some training programs in universities, and I do a lot of coaching for students who are participating in mediation competitions. And what I find is that as compared to the lawyers and judges whom we train as mediators, these young minds are still, unsullied by the litigation experience and the adversarial mindset. So they take to this idea of collaborative problem solving like literally fish to water. Training seasoned lawyers is a completely different ballgame, because being litigators for decades, it's very difficult for them to come out of an analytical, advisory, or argumentative mindset. But when the message goes through, what I found was that when the message goes through about mediation, some of the hardcore litigating lawyers, it's virtually like a religious conversion. And they say there's no fanatic like a converted fanatic. So they become quite fanatical about mediation. And they feel, that this is the way forward. And then I realized that, I was not the only one who was feeling frustrated with the, the litigation process itself. There are others who are equally frustrated. And the moment they come to know that, yes, there is an alternative, they embrace it. Now, I think I need to talk about where we are in mediation as far as India is concerned. Because even if you look at it as a philosophy, are we really, have we really embraced this philosophy? Have we really, because we believe that we had a culture of collaborative, what should I say, problem solving, if you can call it that. Perhaps a culture of dialogue, where we always had this habit of sitting and talking to each other and trying to find solutions. The culture of dialogue is there, but unfortunately, what we are finding now is the progress of mediation in India is very slow. So I'm just trying to understand what is the reason for this slow progress. Why are we still refusing to come out of our belief that justice can only be done in the courts? It's a colonial legacy. The court system is a colonial legacy. And it is very useful. I'm not undermining the court system as such. I believe that based on the concept of legal positivism as it is, I think it serves a useful purpose. Okay, because it has a much larger purpose to serve. Rather than resolving disputes between spouses, family disputes like division of property, disputes with between business partners, businesses and customers. Is that the purpose of the courts? Or should the courts be acting as sentinels of justice to perhaps prevent to prevent oppression by the state of its subjects or by the powerful of the meek? But today, unfortunately, what is happening is, because we believe that justice can only be done by the courts. Sorry, I have a very stuffy nose today. The courts are spending more time sorting out issues that can actually be settled through, process of mutual understanding and agreement, and, spending less time on protecting people against the arbitrariness of the state. Now, it makes me think, where is this belief coming from that courts alone can or should render justice? Just before we started, I was talking to you about this, what happens when elephants are getting trained. So what they do is, the baby elephant, its leg is tied to a post with a strong rope. So no matter how hard and how long the baby elephant tries to pull, it cannot budge the post. So the elephant ultimately comes to associate the rope with an all-powerful, immovable force. And when the elephant becomes a 12-foot tall adult, by simply placing a rope around its leg, you can make it stay put, because it has already resigned itself to the all-powerfulness of the rope. So actually, even though the adult elephant has the strength to break any rope or, uproot nearly any post, we have seen elephants uprooting trees from the roots. But the belief of limitation, it has acquired from past programming in its youth, keeps the elephant immobile and docile. So most of our beliefs, including our religious beliefs, our superstitions, actually come from this kind of conditioning of the mind. So we refuse to, in fact, we are scared to question these beliefs and rationalize them. I think that is where our belief that our problems can be solved only by a higher authority, like the court, comes from. Now, one of the criticisms against mediation is that it is a privatization of justice. It is perceived as an undermining of the civil justice, as a sort of a failure of the judicial system to fulfill its main function of delivering timely justice. So mediation is perceived as a sort of a private contractual phenomenon, as a bargaining exercise based on power relations. And therefore, there is a tendency to condemn it as a sort of an oppressive mechanism that reinforces the inequalities between the parties. My question is, does adjudication not do the same? Do these concerns not exist in litigation or arbitration? And because supposing I have a better lawyer, I have more money to pay for a better lawyer, and I'm able to effectively present my case before the court, and the judgment results in my favor. Is that not inequality against, is it not an oppression of the person who cannot afford that? So, and in fact, the more oppressive part of the adjudication process is that once I am a part of it, once I get into it, I cannot walk out of it. So I have to bear the consequences. I was reading this very interesting paper by Michael Alberstein on mediation and jurisprudence. Jurisprudence, when we were in law school, was always regarded as a very dry subject. I don't know how you looked at it, Vikram. So what Michael Alberstein points out is that, I'm just quoting him here, although some applications of mediation may contribute to oppression and provide privatized justice for legal disputes, there are internal ethical and procedural mechanisms in place whose purpose is to prevent such outcomes. I'll be talking a little more about how mediation marks a departure from the adjudication model of dispute resolution. So, but the fact is, today, our approach to law and legal decision making is that it is a set of rules for judges to apply mechanically to the issues at hand. So the prevailing notion is that law is nothing but a body of formal legal rules, and mastering its internal language is the main business of the lawyer and as well as the legal intellectual. This is again Michael Alberstein. So what is the consequence of this? The consequence of this is that justice becomes divorced from the reality of people's lives. Because there is a fundamental difference between justice according to law and justice as realized by the people who are seeking it. So what you do is equity becomes divorced from the law. And I think there's some judgment of the Supreme Court which says that, when there's a conflict between law and equity, the law should prevail. So whenever there is a conflict between equity and law, as to equity basically means doing what is right, and rendering justice or being just and fair. So if there's a conflict between law and equity, if the law says something and equity demands something else, the law prevails. Now, when I'm conducting these training programs for judges, I have asked this question to many of them. Have you come across instances where you have felt that between the two parties before you, one of them is right, the other is wrong, but the law favors the wrong person and not the right person? And because the law favors the wrong person, because your heart tells that this person is wrong, but you still have to decide in favor of that person because the law says. And invariably, everybody says, yes, there have been many such instances. So my question is, what happens to the affirmation that, we so proudly display in our courts? Fiat justitia ruat. Let justice be done, though the heavens may fall. Does it simply mean that, let's uphold the law, even if it means injustice? What about laws that are sometimes, inherently unjust? What about laws that are just, but their operation results in injustice? Now, for example, some time back, I was reading a report on the POCSO Act, the Protection of Children from Sexual Offences Act, being applied to some tribal youth. So there is, I believe, a custom among these tribes that the young people go into the forest, they spend as couples and they spend some time together. And obviously there's a lot of intimacy between them. And when they come back, they decide whether to get married or not to get married. Now, what happened was some smart aleck decided that, because many of these were they were legally minors, the POCSO Act should be applied and the males were being prosecuted. Now, this is the case where, the law is just, there is a need to protect children from sexual offenses, but its application is resulting in injustice because here is a custom, a tradition, where basically it is consensual and, and people, those tribal youth don't even know what has hit them. They don't know why they're being prosecuted because this is a custom they have been following for generations. So the problem with the existing legal system is the treatment of law as a set of rules which we mechanically apply to decide the issues. Now, what this approach ignores is the fact that behind those issues are people. Living, breathing, feeling human beings who are very deeply affected by these issues and who are perhaps looking for a vindication of their feelings, of how they perceive these things. The question is the law equipped to deal with that? Now, if you go into the philosophy underlying the law, we have the natural law theory, we have the positive law theory, and how the Greek Stoics propounded the natural law theory as being something that is fair and just because nature prefers harmony, and in order for a law to be natural, it has to be inherently just and fair, it has to be good. And how that, transformed into the concept of natural law as being something that is divine in origin, because with the advent of Christianity and even religions like Islam, religions based on revelations, where they believe that, law has to be something that is given by God himself. And then we had the Renaissance, where there was a separation between the church and the state. And that was where legal positivism came about, and people like Austin and others, they came up with this theory that, law has to be a set of rules that the state should implement, regardless of, there has to be a set of rules that have to be applied to basically govern the behavior of people. So I think that relates back to perhaps what the Hobbesian principle, that the Hobbesian concept that basically man is wild and humanity, basically human beings are wild and barbaric and savage, and it is there has to be the concept of the state, as a leviathan that keeps things in order, and so that was how legal positivism evolved.
Right.
Now, in this process, what has happened is we have procedural laws, we have substantive laws, we have laws that, of course, declare the rights and obligations. They define the duties of people. What are the rights that people have? And there are courts to vindicate those rights, to enforce those rights. We have legislatures which lay down these rights. But in all this, going back to what I said earlier, that somewhere along the line, we are forgetting the fact that it cannot be something that is divorced from the reality of how people think and how they behave and how they perceive the world. So what happens is, while the law may provide them with perhaps procedural satisfaction in terms of giving them a fair opportunity, having a fair process of for the adjudication of rights, it may even provide substantive satisfaction to at least one of them if there are two parties in a dispute, but it is not designed to provide the emotional satisfaction. And what happens is, without that emotional satisfaction, there's no actual closure of the conflict. I don't know whether we have the time, Vikram.
We have 3 minutes of your session. One is here. We'll ask her if she lets us continue. Lets you continue. It's all her. After that, it's her show. One, what do you say? Do you have, how much time do you have? Can Jawad extend his session a little bit?
No, just a few minutes more.
One will have to. She has to. Yes, one. Do you think Jawad can go a little longer? We'll have to unmute and tell us.
She's on mute. She's on mute.
Yeah. I'm okay. He can continue, and I just feel free to finish, and then I'm gonna join.
Perfect. Okay. So he has a few minutes.
Yeah, just a few minutes more.
Yeah, please.
Yeah.
You anyway have a few minutes.
No, I think when we look at it from the perspective of emotional satisfaction, I think that's where mediation holds a lot of promise. Because number one, mediation doesn't concern itself with the law, though it operates under the shadow of the law, but it doesn't really concern itself with the rights and obligations as defined by the law.
Right.
It goes beyond that. And it goes into what is more important for the people. Okay. Number two is it gives them that scope for actually talking, actually, expressing themselves, which they don't get, I think, in the other processes, because in the other processes, as I said, it is a set of rules that it all depends on the interpretation of rules. So the experts, lawyers come in the picture, judges come in the picture, and they decide as to, what should be said and how it should be decided. Whereas here, the people are able to talk about what is important for them and how they feel about it. And the third and most important thing is they have the right to decide how they want to resolve this. So I think these are, three of the main very essential attributes of mediation, which differentiated from the adjudicative processes. Now, mediation has evolved because from a purely facilitative model of mediation, which is more based on a problem-solving approach, where again, law plays a significant role in that. We have the transformative and the narrative forms of mediation, where the transformative style talks more about, communication between the parties, between the participants, between the disputants or people who are in conflict. So essentially, it creates the environment for them to speak freely. And in the process of expressing themselves, they find that empowerment. And that empowerment leads to the recognition of the other person's, perceptions or whatever. The narrative mediation is again, because it's based on the fact that, people perceive things differently. So my perception is different from your perception, and I have my own narrative and you have your own narrative, and we talk to each other. And we see whether we can come up with a narrative that is, that works for both of us. So there is a lot of flexibility. Okay, there's a lot of flexibility here. And if you look at it from the theoretical perspective, I think mediation, between the social sciences and the humanities, it swings. And it is more, I think, perhaps premised on the natural law theory, because it ultimately, it recognizes the fact that we are hardwired for empathy. We are hardwired for, collaboration, because that, as hunters and gatherers, that was our survival. Okay, that was the key to our survival. And a lot of research, anthropological research, as well as, other research has shown, archaeological research has shown, that why the species of Homo sapiens survived is not because of what was earlier thought of as the selfishness or the survival of the fittest thing. Survival of the fittest happened because we could work together, we could collaborate together, we could work together as a team. So Yuval Noah Harari talks about how, if the difference between chimpanzees and human beings, though the chimpanzees might be much stronger than human beings, but they cannot function. Like, for example, in a mall, I may not know Vikram, Vikram may not know me, but we don't collide against each other. Okay, we don't fight against each other. You keep going your way and I keep going my way, and I keep doing my thing and you keep doing your thing, without basically having that, the propensity to fight. So essentially, that is the human quality that comes to the fore. The need for survival, the desire to be free of conflict, because conflict is inevitable, but then how do you deal with the conflict? Are we going to have a confrontation? Is it going to be a war that we are going to fight? Or can we just sit across and talk? Now, I'm just putting a very simple perspective here, because there are other, various other complications to it. There are various other aspects of it that need to be looked into, but we don't have the time for all that. Okay. So do we really bargain with the devil? There's a very interesting book by Robert Mnookin where he talks about bargaining with the devil. So if in a situation, do we really bargain? Do we really negotiate with somebody who has been absolutely wrong? Like, could Winston Churchill have negotiated with Hitler? Okay, so these are the questions. So should Ukraine negotiate with Russia? That's a question. So, these are things that there are the other complications. But inherently, the thing is, we are hardwired for empathy. We are hardwired for collaboration. So I think mediation is perhaps, the only mechanism, the dispute resolution mechanism, that gives space for us to work on this, develop it further, and, reach solutions that are more sustainable, that help us to find that, the vindication that we need, the emotional and, other kind of satisfaction that we need. And I think that's where I believe that, as a philosophy, in fact, we need to look at mediation as a philosophy, which has, much deeper meaning to it than what we are now, treating it as simply a method of resolving disputes. It's something beyond that. It's something that we need to explore more. And I think that exploration will happen only when we start, discussing these things. That is where I really, congratulate you on coming up with this idea. As Mr. Panchu said, that, it's really surprising that we have had mediation for almost 15 years in India, and nobody has thought of connecting philosophy with mediation. And it took a Vikram to say that, okay, these two things are connected. Let's bloody well talk about it, right? And the array of speakers that you have brought on this, it's amazing. I mean, the kind of insights that we are getting, and I hope that people start taking this seriously in India, and we really start looking at the culture of mediation from a philosophical perspective. That would, what I feel is, it's important because the theoretical basis is very important for us to build as a foundation, to build upon the other things like what kind of processes, how the system should work, who the mediators should be, and what kind of, learnings there should be for mediators, what kind of frame of mind they should have. Unless we have a theoretical, philosophical basis for that, how are we going to build on it? So I think this symposium, I hope, will really serve that purpose and will lay that, that very important foundation for us to build upon it as really a viable alternative to the court system that we have. It will not replace the court system. I'm not at all talking about replacing the court system. I'm saying that there has to be an alternative so that the court system really discharges the purpose for which it exists and not waste its time in sorting out issues between husband and wife, between brothers and sisters, between partners, between customers and businesses. What for?
Absolutely.
Right? You have better things to do. You focus on that and leave this to people. Develop a system where the people can, feel obliged to sit and talk and resolve these disputes. And if they cannot, that is when you intervene.
Absolutely. I think that's the whole point, that how you have to make it a people's process, basically through the atmosphere, the legislation, which I keep saying, you heard me, we have the best legislation on mediation, and keep it as simple as that, because the people's process, let him connect to that. Because training part, look, we will always in that way, you'll come to what I'm saying in some time, because here we move to a mediator being a philosopher. Now, to be a philosopher takes a lot experiences in life, which is what I keep talking about in terms of my evolution of a mediator series. Your upbringing, the value system, by which yesterday from Andrea's session, you will get that, her talking about her father and what he brought, what she picked up from there. So all that makes you who you are. So that is not, you can't do that in a 40-hour factory. It takes a lot to get there. And this is where being reflective comes in. A lot of aspects come in to reach that point. And I think this direction that it's taking in terms of mediator being a philosopher, I think a very interesting direction. And mediation being philosophy, I think we'll work on this. It's just this symposium was just to put the thought out and just start the discussion, and we'll take it up later when we have enough time. And in terms of, I think the fact that when you talk about the law, and sometimes people connect that lawyers doing mediation or knowledge of law, and one is here, one is not a lawyer, she's going to come in. But the point is, when fair, reasonable, equitable people sit together and they resolve something, that should be the law. Yes. If that is not the law, challenge the law. Don't challenge the process. That's the whole idea. And when you talk about the situation in the courts, in terms of whether justice is being done, the fact that there are some people who can't afford what we say a good lawyer, I mean, however you define a good lawyer, and you have senior advocates on one end. I'm saying that the courts have to look at systems where in your legal aid also, the same quality of lawyer, in terms of you have a senior advocate here of certain thing, you have a senior advocate on that side, then I can understand some justice is happening. So justice in a lot of ways, justice being delayed is a problem, justice in that way, a lot of aspects. So that's not even, I don't talk about the court system, so I'll leave that out of it. But anyway, so I think today, because we were short of time, I kept half-an-hour sessions only because I felt that let's get in more people, but we'll carry the conversation forward. So Jawad, always a pleasure. Thank you very much.
Thank you for the opportunity, and I will have to step out now because I have some guests. But
Perfect. So I'll just stop this live stream and I'll see you then. We will talk about the India Mediation Circle and we'll take that forward.
okay.
All right. Bye. And I put in the comments, I put out the conversation that you and Anis and I had in Conversation with a Beautiful Mind. People should watch that. It was a wonderful conversation to get to know more about Jawad on a personal side. So